verdict. What were your initial thoughts on the verdict when you heard it?
Oh, I think the judge was pretty clear in terms of how she parsed out the liability. You know? But I haven't, of course, read the entire decision because I'm waiting for it to be uploaded in the Supreme Court website. But the judge made the distinction between principal accused and accessory accused. And she also made clear that the principal accused would all suffer a specific and similar penalty, which is reclusion perpetua without benefit of parole. The accessory accused, those who are accused of being accessories, were punished with a penalty that is 2 degrees lower, which is 6 years and 1 day to 10 years. So that's the first. I think the judge would have, at arriving at that particular characterization, would have gone through each and every part of the evidence that was presented, distinguish as to the roles of each person. So that's the first. That's my first takeaway. The judge was pretty clear as to who should be liable and why. The second thing is that the judge also made findings of civil liability, meaning she awarded amounts of money for each of the victims and their families. You know? And while it was not read out loud, the items of damages are in the decision, which was posted by the Supreme Court PIO. And you will see there that the judge made 4 awards. No? First is an award for the death of whoever was a relative. It's a uniform amount of 100,000. So basically, that's the court's appreciation of how much a human life is worth, 100,000.
Okay.
The second one is moral damages, which goes into the anxiety one feels as a result of being the victim of a crime. So that's to compensate for all of those, no? Mental anguish, sleepless nights, all of the moral damages, moral injuries that's inflicted. The third one is exemplary damages. It's intended as a measure to deter any future conduct similar to this.
Okay.
So for those 3 items, the court awarded a similar amount of 100,000.
Okay.
Which I think many lawyers would probably say, except for the monetary compensation for the death, 100,000 for moral and exemplary damages would be on the low side.
Okay.
So, but the 4th item of damages awarded by the court is for loss of earning capacity.
Yes.
And that's where the court made differentiations, because that would be subject to proof as to how much the person was earning at the time, how long the person was expected to live, and how productive the person would be if, for example, she or he had lived to be, let's say, 60 or 70 years old. So there's a table for that. There's a computation that's based on actuarial math, the math that insurance people know, and so that's subject to proof. So that's why you would see for some items the court awarded lows of 100,000+. For some, she awarded millions. So that really depends on the person involved. So that's the second thing that's significant. The third thing that's significant is, of course, the acquittals. I think many would have been surprised by the number of people acquitted, because I think there were more, if I'm not mistaken, there were more people acquitted than convicted. So for those who were acquitted, I'd be very curious, because again, I'd like to read the decision as to why they were acquitted. But of course, the general finding of the court was there was not sufficient evidence. There was not enough evidence to prove their guilt beyond a reasonable doubt, because the standard of proof is very, very high.
Yeah.
So that's basically my takeaway. It's a significant decision. It's 10 years in the making. One of the more spectacular crimes that have been discovered in Philippine history, involving 32 journalists, 58 dead. So it's a good decision. But again, people would argue probably it's not good enough. It's incomplete. There were acquittals. So we would have to wait for what the higher courts, Court of Appeal, Supreme Court, would say on the convictions.
Speaking of acquittals, si Sajid Islam Ampatuan was
Right,
acquitted.
right.
Was this expected, given that he was allowed to post bail?
Well, in a sense, yes, because if you're allowed to post bail for a non-bailable offense, that's the court's finding that the strength of the evidence of the prosecution up to that point is not strong enough. But of course, there have been, instances when a judge, even though she or he would grant bail, would still convict because maybe the totality of the evidence was more than enough at the end. No? But unfortunately here, the judge said Sajid, who had been granted bail earlier, would be acquitted. So again, I'm sure that's one thing that many people would want to read in the decision of Judge Solis Reyes. Why did she find that the evidence was not strong enough or did not measure up to proof beyond reasonable doubt?
And he didn't even show up.
He
even though
didn't
he
show
was
up.
given
Yes,
notice.
that's right. And well, of course, he was being asked to explain because that's actually contempt of court.
Yeah.
And if he had been convicted, he would have lost his remedies. He would not have been allowed to post bail. He would not have been allowed to appeal. The decision would have been final immediately as against him. So for him, it was lucky for him that he was acquitted. So all he has to do now is to explain to the court why he was not there.
He just has to explain, and then that's it?
That's
off
it,
the
because
hook
he's
na?
been acquitted.
Okay.
There's nothing left to be done.
So no more penalties for him.
Well, not insofar as these cases are concerned. So an acquittal cannot be appealed because of the prohibition against double jeopardy.
Yeah.
So that's it for him.
You spoke about the damages that were going to be paid to the families, and you were saying it was kind of low, on the low side for moral damages, exemplary damages. But the prosecution actually asked for 20 million for each family. Do you think that was wishful thinking?
Well, I think that's Attorney Roque's number, 20 million. And again, it's really based on evidence, right? But 20 million is high for each family.
Yeah.
That's on the high side. But on the other hand, 100,000 for moral damages arising out of a particularly gruesome killing. We need to remember that they were not just killed. They were ambushed, they were lured, they were ambushed, and then for some, they were basically tortured. And then, of course, the bodies were hid in a particularly, again, gruesome way, right? They were buried in their cars. So, no, it's not an image that's easy to forget.
Yeah.
So, 100,000 for moral damages, that's not, that's on the low side.
Yeah.
For exemplary damage, 100,000 is also on the low side because if the purpose of exemplary damages is to deter future misconduct. And so the amount of damages should be enough to hurt without necessarily being excessive. 100,000, considering who some of the accused are, is on the low side. But again, 20 million for each might be difficult to prove. Again, subject to proof. If, for example, they're able to prove that this person, if she or he had lived to be 60 years old, would have been earning close to 10 million, then maybe yes. But as a general item, 20 million for each family, that's pretty hard for the judge to award. But yeah, I would have been looking for a number, somewhere in the middle.
Okay. So what are the next steps for the families of these victims? How do they go about collecting damages, and how long do the settlements
They would have
take?
to wait for the judgment to become final. And so,
Okay.
presumably, of course, those who were convicted, they'd go up. They would file probably first a motion for reconsideration within 15 days. Whatever the result of the motion will be, then they will go up on appeal. If they lose their motions for reconsideration, they go up on appeal to the Court of Appeals. Then if they lose there, they go to the Supreme Court. So that takes a number of years again. And presumably, they would also appeal the civil liability. Now, as far as the complainants are concerned, they have the option of appealing the civil liability, the award, meaning they can say, we prove a much higher amount, and so you should have given us a much higher amount. So that's an open question for them as well. So once the decision becomes final and the award is final as well, they can now execute the decision. They go back to RTC 221, and they file a motion for execution. They say, we want to collect this amount. And then the judge will issue what is called the writ of execution. They would go after the monies or properties of the accused or the convicts now. And if there is sufficient monies or properties, then they would satisfy the judgment. If there is none, they would have to wait and look for properties to satisfy. So again, that might take some time.
Do you think it's going to be another 10 years?
I hope not, but realistically, maybe yes. Again, given the number of convicted people, the amount of the volume of files that have been compiled through the years of 10 years of litigation. It goes to the Court of Appeals. The Court of Appeals so that they review all of the files. Assuming they lose, they go up to the Supreme Court. Same thing for the Supreme Court. So yes, realistically, maybe another 10 years.
Okay. And do you think the 10 years that have passed, do you think that is normal for a multiple murder case like this? Is that the new standard?
It's not normal in the sense that it's the first time we've had this. Right?
Okay.
100 plus people. But again, perspective-wise, you're talking 100 plus people, 10 years. That's practically 1 year, right, for every person.
Yeah.
So that's short.
Okay.
That's actually short, right?
Okay.
And so 10 years is not a long time if you're talking about 100 plus persons. And the second thing there is that if we had moved it quicker, if the judge had moved quicker, she might be open to a charge of, denial of due process. The accused would probably say, you denied me my day in court, you were rushing to judgment. So I think to be on the safer side, I think the judge did pretty well in, giving a lot of leeway for the accused to be heard, giving every opportunity to be heard so that she could eliminate that argument when it goes up on appeal. Because presumably the accused would say, we were deprived of our right to due process. And if they win that, then that's a big win for them. So, in my opinion, 10 years, considering the number of accused, it's not a very long time.
It's not a long time, but the families were, for them, it's a very long time.
Of course, experientially, for them, it is a long time.
Is there anything we can do, any reforms that we can have to speed things up in our judicial system?
I think some of the reforms that have been put in place here might work for a similar case. And of course, I'm hoping that there is no other similar case. But if you look at the 2013 Ampatuan guidelines that were issued by the Supreme Court, specifically for this case, many of those reforms could actually work. For example, the use of judicial affidavits in criminal cases. It removes the time needed for direct examination of a witness by a lawyer. So it automatically, you just submit affidavits, you go immediately to cross-examination. The judge was allowed, in this case, to render partial judgments. As soon as one person had terminated the presentation, she could already rule. She opted not to, but she was allowed to by the court. Because the significance of that particular rule is that this is a consolidated case. She was supposed to render one judgment for all the accused. She was allowed to by the court, by Supreme Court, to render one judgment at a time. As soon as she could end one case, she could render it. She opted not to. She opted to render one judgment for all. I think from her point of view, she was appreciating it as a totality. And so it was important for her to render a judgment as a whole. So, but some of the reforms that have been put in place because of this case are important, and they can be replicated should a future case of this magnitude come in. Again, I'm hoping that there is none that would involve 58 dead, 100 plus accused. But if it should come to that, then some of the reforms would work.
Going back to the number of convicted and the number of acquitted, you were saying there were actually less convicted, right?
Yes, if my counting is correct.
Yeah,
yes.
it was. There were 28 convicted.
Right.
But there were 197 accused in total.
Right.
Do you still consider this a win for the victims and their families?
Oh yes, it's definitely a win. It's a big win. It's a big verdict. Simply because the family has never been out of power. They remain very influential. They remain very powerful.
Yeah.
They remain well connected. They remain very rich. And so it's a brave statement by the judge to convict 3 Ampatuans, even though she acquitted Sajid, but to simply say they are convicted and sent to prison for 40 years without benefit of parole, that's a very, very big win. No matter how many, if there are lesser people convicted than acquitted, I think that's still a big win.
Okay.
And it shouldn't be that judgment, that verdict shouldn't really be characterized as anything less than that.
Okay. They were convicted of 57 counts of murder, but there were 58 people who died.
Yes.
And could you tell us why it's that way?
The 58th person, Reynaldo Momay, his body was never found.
Yeah.
But he was reported as having been part of that group, and therefore presumed to have been part of the group that had been killed. he was identified to have been there because of his dentures. And so, but because his physical remains were never found, I think it became difficult for the prosecution to actually prove that someone had been killed. And again, because the standard of proof is very, very high, proof beyond reasonable doubt, it's an extremely high burden. Part of that burden is to prove that someone was actually killed, someone actually died, and that this person was killed by these accused. And that's the reason why in that one separate case, Momai's case, the court acquitted the accused, largely because his remains couldn't be found.
Are there any prospects of Momai's case prospering at all?
Since it's an acquittal, no. But I recall hearing Attorney Roque, who was the counsel of Momai, saying that he would appeal the civil liability. And that's a significant motion, because what he's saying is that even if the death of, if the killing of Momai could not be proven because of lack of proof beyond reasonable doubt, he's saying that as a civil case, the killing could be proved because the burden is less. It's preponderance of evidence only. And so it could be shown that, yes, he was part of those killed, even if the remains are not there. So possibly what Attorney Roque was saying earlier is that he should have been awarded civil indemnity, civil liability.
Okay.
As a civil, in the civil aspect, not in the criminal aspect. So that's the only possible remedy. But because they were acquitted, they can't do anything about that.
So will they have to open a new case
They
for
cannot
that?
they cannot open another criminal case.
Oh,
They will
okay,
have
okay.
to work within that particular case. And that's why the only thing that the counsel can do there is to move for reconsideration of the failure to award any damages. That's the
Okay.
only thing that's left. On the criminal side, they cannot do anything about it because the accused have already been acquitted.
Okay. And so those who were acquitted will serve 30 years in prison?
40
and not
years.
40.
40
Okay.
years. They've been sentenced to 40 years without benefit of parole. That there's a distinction there because ordinarily the penalty is up to 40 years. 20
Yeah.
years and 1 day to 40 years. That's reclusion perpetua. Here the judge sentenced them to reclusion perpetua without benefit of parole under 9346. Republic Act 9346 is the law that prohibited the imposition of capital punishment. And in place of capital punishment, the law says reclusion perpetua without benefit of parole is the substitute penalty.
Okay.
So because these acts were done when at the time when capital punishment is no longer allowed, what the judge did was to say reclusion perpetua without benefit of parole, maximum 40 years. But because they had spent 10 years in jail already,
Yeah.
so under preventive detention, they would have 10 years credited to them.
Okay.
So they would need to serve an additional 30 years only for the remaining for the 40-year period.
And will they be covered by the GTCA law?
Depending on which period of detention we're talking about. If you're talking about the 10-year period of preventive detention, no. Because the law is clear, the law was amended, and it prohibits the GCTA, the Good Conduct Time Allowance, for the preventive detention part.
Okay.
But for the service of sentence part, the remaining 30 years, the law does not prohibit it. So yes, if they are found to have good conduct, if they are given allowances, those allowances can be given to them.
Even if it was a heinous crime?
Yes, because the law itself does not prohibit it.
Okay.
Only the implementing rules of the DOJ prohibit the imposition, the award of GCTA for heinous crimes. And that's being questioned now before the Supreme Court. And my basis for saying that they should be given the GCTA is because the law does not prohibit it. And because the law does not prohibit it, an administrative regulation cannot legislate a prohibition where none exists. So the state of the law is preventive detention, no GCTA for heinous crimes, but for service of sentence, you can still have GCTA for heinous crimes.
Okay. Okay, sir. That's all.
All right. You're welcome.
Thank you.